तो सारे लोग अच्छे हैं? Are you feeling good, happy, or is there any unhappiness around you or inside you? Hmm? तो कोई अनहैप्पीनेस नहीं है, कुछ नहीं है ऐसा. All are good and happy. That's really great. I am also happy. That's good. Are you solving the test? Are you solving the questions? So let us begin with this Order 6, Rule 17. Order 6, Rule 17. Now this deals with amendment of pleading. Order 6, Rule 17. Order 6, Rule 17 deals with the amendment of pleading. We have already read that what is pleading? Pleading is plaint for the plaintiff and written statement for the defendant. And on the basis of this pleading, we formulate issues as per Order 14. And this pleading is meant to bring out a clear case before the court. So it is advised to all that they should draft their plaint and written statement in such a way as to bring clarity in their case and as to facilitate the understanding of issues by the court and the opponent. So this is very much necessary that we should bring all real question for determination of court in the pleading. But the fact of matter is that the pleading is not drafted or crafted by the party. It is done by the lawyer. And lawyer may be in hurry to put forward the case before the court. So there may be inadvertent mistake, there may be certain omission, there may be certain mistakes. So we need to provide opportunity to amend the pleading, because for the fault of pleader, the party should not suffer. Courts are meant to do justice and not to penalize the parties. So in this context, it is very important for all of us to understand that for determination of a real question, real issue, we should allow amendment. We should allow amendment. We should allow the parties to amend their pleadings. And furthermore, there are many other rules which prevent you to bring suit on the related things. We have already discussed Order 2, Rule 2, where we have written that all claims, all reliefs should be claimed then and there. Order 2, Rule 2. And if you do not claim it, then you will not be allowed to file the subsequent suit for the same matter. And it is also one of the main purpose of law that there should be minimization of litigation. There should be minimization of litigation. So how will you minimize the litigation? Order 2, Rule 2 suggests that. There is principle of res judicata. Res judicata says that if you have not raised the issue when the matter was put up before the court, then later on you cannot raise that issue which should have arisen there. There is res judicata and there is constructive res judicata. The matter which should have been raised there, if it did not have been raised there, then it will be considered to be raised and it is constructive res judicata. Why did you not raise it at the right point of time? So you will not be allowed to do that later on. Constructive res judicata will apply, or res judicata will apply. In this context, amendment of pleading acquires immense importance. But at the same time, we should keep in our mind that this amendment at any stage, every stage, creates such situation where case is pending before the court for many years, and it will be misused for the purpose of delay. When I know that my case is not going to be decided in my favor, I will use different tactics. And obviously the legal minds are expert enough to create such situation which will favor them. Now this is another aspect. We know that justice delayed is justice denied. So what we are saying, that we are required to balance two interests. The party should not suffer for the fault of a lawyer or for any reason which has not been claimed earlier. He should not suffer due to that reason. He should be allowed to do it later on, as he is barred to bring another suit on the same matter before the court by virtue of Section 11 of CPC or by virtue of Order 2, Rule 2. On the other hand, there is another interest that justice should not be delayed. So we are required to balance the two conflicting interests. Now this balancing of interest requires understanding of this law, that how amendment of pleading can help the parties to bring forth the points which is necessary for determination of real issue, and how it should also counter any kind of ways and means adopted by lawyer, smart lawyer, to delay the procedure, to delay the trial of the case. We are required to balance the two. So in this context, we'll be reading this amendment of pleading. Considering this fact, that this has been used by lawyer to delay the case, it has been misused many a times. the legislature thought that it will be better to put a kind of restriction on this amendment of pleading. And they inserted a proviso in year 2002, proviso to Order 6, Rule 17. And that proviso clearly says that once the trial begins, then it should not be allowed unless and until the omission was such that even after due diligence it was not possible and it is necessary for determination of real issue. If you see the proviso added in year 2002, no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So Order 6, Rule 17 says that no application for amendment shall be allowed after the trial has commenced. But it does not snatch the power of the court. It says unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So if the court comes to this conclusion that in spite of due diligence this was not possible to be done before, it will allow amendment of pleading. It will allow amendment of pleading even after trial has commenced. Then we are required to understand this law in the context that if you see the main provision of Order 6, Rule 17, it says court may at any stage of the proceeding, at any stage, may, discretion is given to the court, allow either party, that is plaintiff or defendant, to alter or amend. Alter means he can change it altogether. Amend means he can do minor modifications. His pleadings in such manner, pleading is plaint for plaintiff and WS for defendant, and on such terms as may be just. And all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy. So court should be convinced that it is necessary for purpose of determining the real question in controversy. If it is so, it shall be allowed for determination of real question in controversy. So in this context, you are required to understand the law of amendment of pleading. Is this clear? So now first you have understood the word pleading. Pleading is plaint for plaintiff and WS for defendant. Amendment means what? Amendment here in context of Order 6, Rule 17 means that you can alter or you can amend. You can change or you can make minor modifications. Both are possible. Now we'll be discussing this. But there are various kind of amendments in this CPC. Apart from Order 6, Rule 17, which deals specifically with amendment of pleading. So when I say amendment of pleading, I am referring to Order 6, Rule 17. But there are other amendments, which is not amendment of pleading. There are other amendments also in this CPC. So let us have cursory view of those amendments also in CPC. That is interesting and maybe a question in preliminary as well. Amendment of pleading is important both for preliminary and mains, and it is otherwise very, very important for a lawyer and judge to know that what are the rules, regulations of other kind of amendments. One is amendment of pleading, and then there are other kinds of amendment in CPC. Other kinds. Now, so one amendment is in section 152 of CPC. So you just visit this section so that you can study them together, related issues, related points. Let us see 152. It says amendment of judgment, decrees or order. So you may be asked a question in preliminary: amendment of judgment, decree, order is discussed where, in which section relates to it. So that is what is relevant. It says clerical or arithmetical mistakes in judgment, decrees, order, or errors arising therein from any accidental slip or omission may at any time be corrected by the court, either of its own motion or an application of any of the parties. So, what Section 152 does? Section 152 empowers the court to amend what? Judgment, and correctly so, because the act of court or the action of court should not injure anybody. So if there is any error, let us correct it. Judgment, decree, or order, or errors arising, it empowers the court to amend judgment, decree, or orders, or errors. Judgment, decree, order, or errors arising therein from any accidental slip or omission. Arising from what? This is other kind of amendment in CPC. It is not amendment of pleading, but as it is a related thing, so we are discussing here in brief, because it does not require elaborate discussion. So amendment of judgment, decree, orders, or errors arising from accidental slip or omission at any time. At any time. Be corrected by the court. This is how you are required to read Bare Act. Corrected by the court. This is how you are required to read Bare Act. Many people may have some difficulty, but this is how you can bifurcate, dethread the provisions, and you can read them carefully, so that you can prepare well for preliminary, apart from understanding the law clearly. So be careful, learn the method. Corrected by the court on its own motion, that is suo motu. Court can correct it on its own motion or on application of the parties. Or on application of any of the parties, any of the parties. No sufferance at part of other on account of my mistake. So now, due to court's mistake, nobody should suffer. And court should not do any act which will injure the interest of any of the parties. So court has to be careful, so it can be done suo motu or on the application of parties. So I hope you understand, it's very simple law. Those who understand English, for them I have already spoken that court can at any stage correct errors, amend its errors. It can amend judgment, decree, order, or errors arising out of accidental or arithmetical slips. Maybe now instead of 50,000, you have written 5,000. You wanted to write rate of interest at 6%, you have written 16%. Maybe. Or you mentioned some incorrect facts or something like that. Maybe error or accident may arise. It is human to err. To err is human. So in that context, the court should have opportunity to examine this and to correct it. It can be brought to the notice of court by the party, plaintiff or defendant, or it can be done by the court. And it can be done at any time because it is such error which must be corrected. It has nothing to do with the stage. Court must correct it. So at any stage, at any time. It is not written at any time before trial commences or something like that. So error should be now. Even if you have error, I have error in my method, in my thinking, it must be corrected today or tomorrow. Must be done as early as possible. So I hope everybody understands this very simple amendment of judgment, decree or orders, and this is section 152. I think even Hindi speaking people must have learned because it's very easy to understand. भाई कोर्ट जो है देखिए किसी भी प्रकार की यदि कोई गलती है जजमेंट में, डिक्री में, ऑर्डर में, तो उसका करेक्शन कर सकता है, किसी भी समय कर सकता है, आइदर ऑन इट्स ऑन मोशन, सुओ मोटो जिसको आप कहते हैं, और ऑन एप्लीकेशन ऑफ द पार्टीज. द पार्टी कैन ब्रिंग इट टू द नोटिस ऑफ कोर्ट एंड कोर्ट कैन डू इट. कोर्ट उसका करेक्शन कर सकता है, कोई बड़ी बात नहीं है. So this is section 152. I have written in your Bar Act also. Enables a court to vary its judgment as to give effect to its meaning. Maybe that judgment does not reflect what the court wanted to say, but only clerical or arithmetical errors arising from accidental slip can be cured under this section. Therefore, the party cannot claim substantive relief by any such amendment. Now, substantive relief cannot be claimed by way of amendment. Proper test to check whether an amendment under section 152 is to be allowed or not, the proper test would be to assess the decree represents the intention of the judge who made it. If it does, then any mistake, it cannot be treated as accidental slip or omission. So it should reflect the intention of the parties. If I remember correctly, there are provisions in a specific relief act also which talks of that intention of the parties should be reflected in the document, otherwise the document can be rectified, rectification of instrument. No. No party should suffer any detriment on account of mistake or error committed by an adjudicating authority. And the court should have duty to see that records are true and present the correct state of affairs. Yes. Somarendranath Sinha versus Krishna Kumar. Krishna Kumar Nag. Important point. Important point. Somarendranath Sinha. I have written your Bar Act. Not important case, but just for your information, Somarendranath Sinha. Somarendranath Sinha versus Krishna Kumar Nag. This is not to be remembered at all. This is just for your information that I am writing this case. AIR 1967, Supreme Court 1440. What it says that the provision of section 152 is based on two important principles. Two important principles. What are these two important principles? No party should suffer, no party should suffer any detriment on account of, no party should suffer any detriment on account of a mistake or error committed by court, that is adjudicating authority. And number two, it says and number two, it says the courts have duty. This is not only parties' duty, the courts have duty to see, have duty to see that the records are true and present the correct state of affairs. The correct state of affairs. The correct state of affairs. It is the duty of court also to see that the records are true and present the correct state of affairs. It is the duty of court to see this. Is this clear? Now, going further, section 153. Section 153, general power to amend. Now, this can be again another question. General power. So it says court may at any time on such terms as to cost or otherwise admit think fit amend any defect or in any proceeding in a sort. And all necessary amendments shall be made for the purpose of determining the real question or issue raised by or depending on such proceeding. So again it says the court may means discretion. Court has discretion. Court has discretion. What is the stage? At any time. At any time. At any time. On what basis? On such terms as to cost. It can impose cost on the party. As to cost or otherwise. It can be done even otherwise, without cost. Amend any defect. So this is general. This is not related to this judgment, order, decree or arithmetical or clerical errors. Amend any defect or error in proceeding. Amend any defect or error in proceeding. And all necessary amendments shall be made for purpose of all necessary amendments shall be made for a determination of, shall be made for determination of a real question or issue depending, real question or issue depending uh, so now I said determination of real question or issue raised by or depending on, raised by parties or depending on such proceeding. What is the need of correction that will be seen in that case, and accordingly general power to amend the provision will be exercised by the court. This is general in contrast to 152, which talks about a specific thing, which talks about what can be the object of allowing this amendment. And I have already said this is to minimize the litigation, so let us amend it here and avoid multiplicity of proceeding, and to ensure that mere technicality may not be allowed to extend in way of substantial justice. Thus, a court can treat an application made under a wrong provision of law as one filed under the correct provision without dismissing it. So, if somebody is not aware and he writes an application and he writes or he quotes the wrong provision, it is duty of court to see that it should be treated as correct one. We have dealt it earlier also. I have told you now that if some incorrect provision of law is quoted, this is a minor issue and it should be corrected. So that can be done under the power of court in section 153. Somebody writes instead of order 6 rule 17, order 6 rule 18 or 16 or 7 maybe now, but the sum and substance of application is very clear that it is for amendment of pleading. So we'll treat this petition as order 6 rule 17. Is this clear? So that is what we have read earlier also, that this kind of minor problem should not come in the course of justice. Is this clear? All right, my dear friend, general power to amend. So this is general. Now there is a case also, Jairam Manohar Lal versus National Building Material Supply, Gurgaon, 69 Supreme Court. Rules of procedure are intended to be handmade to the administration of justice, and therefore the provisions ensure that technicality does not stand in the way of substantial justice. A party cannot be refused relief merely because of some mistake, negligence, inadvertence, or even infraction of the rule of procedure. Party should not be allowed to obtain justice due to this kind of mistakes and problems. And that is why court has this enormous power to amend as per its need and necessity. Power to amend decree or order when appeal is summarily dismissed, section 153A. This is also an amendment. Section 153A. Section 153A. It is to amend a decree or order where appeal dismissed. Now it says where appellate court dismisses an appeal under Rule 11 of Order 41. Order 41 deals with appeal from order. The power of the court to amend under section court to amend under section 152, the decree or order appealed against may be exercised by the court which had passed the decree or order in the first instance, notwithstanding that the dismissal of the appeal has the effect of confirming the decree or order as the case may be passed by the court of. So even if now anything which is erroneous, which has not been corrected earlier, and now an appeal has been filed on that, and court does not listen to the appeal, court summarily dismisses it. So the decision of lower court is confirmed that in another way, so that in error is perpetuated. So is it not duty of court to correct such errors? Or is it not duty of court to see that this perpetuation of error should not continue? It's wrong. So 153 says where appellate court dismisses an appeal under Rule 11 of Order 41, the power of the court to amend under 152, the decree or order appealed against may be exercised by the court which had passed the decree or order in the first instance. So that court will again, notwithstanding the dismissal of appeal has the effect of confirming the decree order as the case may be passed by the court of first instance. So it says where appellate court has dismissed appeal from judgment, decree, or order, etc. What is this order 41, rule 11? Let us have a glance. Appeal from original decree. Appeal from original decree. Decree is always appealable. The power to dismiss appeal without sending notice to lower court. So this is what is rule 11. Power to dismiss appeal without sending notice to lower court. So court can dismiss appeal without sending notice to lower court. So where appellate court dismissed appeal from decree, you can write now leave judgment here. Now then it says the power of the court to amend the decree or order appealed against may be exercised by the court which had passed the decree. So where appellate court has dismissed appeal from decree passed by lower court, and which has effect of where appellate court has dismissed appeal from decree passed by lower court and which has effect of confirming decree or order, even then the court, that is the lowest or first instance court, that is the court which has passed the decree, then the court can amend its decree or order. This is not barred. So basically 153A says that even if appeal has been dismissed by appellate court which has the effect of confirming the order of the lower court, it does not bar the lower court to amend its decree or order, because that amendment is necessary. Perpetuation of wrong is not proper. The act of the court or the record of the court should not be wrong. So even if the appeal is dismissed against the decision of lower court, whereby the lower court decision is confirmed, even in that case, wrong is wrong. Wrong must be corrected, even if it has been ignored by the upper court. The lower court retains its power to amend that incorrection which is there, amend that mistake which is there. That is what is 153A. This is what is 153A. The lower court is not barred to amend its error. Striking out pleadings. Order 6, Rule 16. Order 6, Rule 16. Court may at any stage again it says court may at any stage. What it can do is strike out or amend Let us see Order 6, Rule 16. Let us have a glance. So it says, court may at any stage of the proceeding order to be struck out or amended any matter in pleading. Any matter in pleading. Court may, this is power of court, to do what? Strike out or amend any matter in pleading. Which may be unnecessary, scandalous, frivolous, vexatious, which may tend to prejudice or embarrass, delay the fair trial, or which is otherwise an abuse of the process of court. Now, what can be amended? So it says A, which is unnecessary, scandalous, frivolous, vexatious. B, which may tend to prejudice, embarrass, or delay the fair trial. And third, it says which may tend to prejudice, embarrass, or delay the fair trial. And the C, it says which is otherwise an abuse of process of court, which is otherwise an abuse of process of court. Which is otherwise an abuse of process of court. Otherwise an abuse of process of court. So in these cases, we can compulsorily, now this is, see these things are, which is unnecessary, it must be avoided. Which will prejudice or embarrass or delay the fair trial, that must be avoided. And which is otherwise an abuse. So in these cases, it is called compulsory amendment. It must be amended. It is not option, it is not voluntary, it is not your choice. If the other party brings it to the notice of court or court comes to know this fact, then it will be amended. So court may at any stage order to be struck out or amended. So court will order. It is not your choice like in Order 6, Rule 17, that is your choice and you go to court and you say that I want to amend my pleading. No. It is a court which will compel you to amend the pleading. It is compulsory. These are compulsory amendments. Because this is not in spirit of justice. Justice cannot be done like this when there are unnecessary, vexatious, frivolous things there in the pleading, or where there are such things which will abuse the process of court. So this is not done. This is unnecessary. This is uncalled for. So it must be amended. Court will compel you to amend it. So unlike Order 6, Rule 17, where you go to court and you pray, here the court will order you to amend the pleading. So it has to be done. It is called compulsory amendment. It is called compulsory amendment. So I have written in your Bare Act again, the power provided under this rule may be exercised by the court either suo motu or on application of parties. Even parties can bring it to the notice of court, or even the court can take notice of this fact. Striking out here means that the paragraphs will not be read as part of the pleading and thus no evidence shall be given to its proof. This striking out may be ordered at any stage of the proceeding. So it can be done at any stage, number one. And number two, can be done suo motu or on application of any of parties. And this is called compulsory amendment. This is called compulsory amendment. This is called compulsory amendment. Compulsory amendment. And then there are other amendments. Order 1, Rule 10, Sub Rule 2. Let us see. Order 1, Rule 10, Sub Rule 2. Court may strike out or add parties. Order 1, Rule 10, Sub Rule 2. Can you see this? Order 1, Rule 10, Sub Rule 2. Striking out or adding parties. You have already read this. So if a wrong name is written, it should be deleted. The wrong party should be deleted. Wrong plaintiff or defendant, or adding parties, and right parties should be added. So this is also amendment. 152, 153, 153A, and then Order 6, Rule 16. This is number 5. Then number 6. Order 22, Rules 3 and 4. Let us see Order 22. Order 22, Rule 3 and 4. Procedure in case of death of one of several plaintiffs or of sole plaintiff. So if there is sole plaintiff, then representative will be added. No? Procedure in case of death of one of several defendants or sole defendant. So this is plaintiff and this is defendant. So if any defendant dies, his representative will come, or any plaintiff dies, his representative will come. So what will you write here? You write here, adding legal representative. Adding legal representative of deceased party or parties. If there are multiple defendant or multiple plaintiff and few of them have died, so their legal representative will come in the picture. So Order 22, Rules 3 and 4. Adding legal representative of deceased party or parties. Is this clear? So we have read 6 kind of amendments. 6 kind of amendments. Then there is this amendment amending your own pleading. Order 6, Rule 17. Amending your own pleading. Is this all right? Amending your own pleading. Before I proceed on Order 6 Rule 17, just have a glance of what is this Order 6 Rule 17. Look into your material. I join you in 5 minutes. All right? I join you in 5 minutes. ऑर्डर 6 रूल 17, तो मुझे लगता है कि आपको सारी बातें मेरी पीछे की तो समझ में आ गई होगी, because that is not very difficult to understand. Order 6 rule 17 is basically about voluntary amendments, amending your own pleading. In contrast to Order 6 rule 16, where you amend others' pleading, that is compulsory pleading. You bring it to the notice of court that see, there is something unnecessary, frivolous, vexatious in others' pleading. But in contrast to that, in Order 6 Rule 17, you amend your own pleading to bring real matter and controversy before the court. I told you already that, see, there are twin objectives to be met here. We do not want multiplicity of suits, so we will allow the amendment of pleading to bring all matter before the court in this case only. So it should be done as much as possible. This is one end. And another object is that it should not be allowed to be a ploy for pleaders to win time, to delay the trial. It should not be done. So we are required to meet this twin objective. I brought to your kind attention Order 2, Rule 2, where we have said that if you do not make all claims and all reliefs in one suit, will not allow this to be done later on. There is definite bar in Order 2, Rule 2. Similarly, I quoted Section 11 and I said that if you do not raise any matter which should have been raised here, then you will not be allowed to raise it afterwards. We will not. Is this clear? Suppose you have been dismissed from your service and you bring it to the notice of the authority that this dismissal has not been done after following the due process of law, like principle of natural justice has not been followed. I have not been heard. You have certain defenses in Article 311 of Constitution. You know that if you fall in that category, 311 of Constitution gives certain safeguards to civil servants. So you have not been heard and you have been dismissed. But there is another safeguard available in 311, that this can be done only by authority who is of equivalent rank or superior rank. It cannot be done by any person who is of inferior rank. So you did not bring it to the notice of court that it has been done by a person of inferior rank. And now you want to raise this matter in another suit before the court. Will you be allowed to do it? No, constructive res judicata will apply. So these are the different methods adopted by procedural law to prevent multiplicity of suit in one cause of action. So this is one basic objective of law, and another basic objective of law is that justice should not suffer. Justice should not suffer. So we are saying that amendment of pleading is a necessity, both for plaintiff and defendant. But up to what time? Up to what stage? On what basis? And what was the need of bringing this proviso in Order 6, Rule 17? Is this clear? So that is what is required to be done. That is what is required to be learnt here in this class, in today's lecture. So, see, when I see this Order 6, Rule 17, I find it is in two parts. The main provision and the proviso. The first part is discretionary, there is no doubt about this. First part is discretionary. First part is discretionary. First part is discretionary. Now, if you read first part, it says, Order 6, Rule 17. Just have a glance. Order 7. It says the court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner. So the first part is discretionary and gives wide and unfettered discretion to decide on case-to-case basis whenever it appears to be just. Court may or may not allow. So you can write down here and gives wide and unfettered power gives wide and unfettered power or discretion, you can say, discretion to court to decide on case-to-case basis. Decide on case-to-case basis whenever it appears to be just. Whenever it appears to be just. The court may or may not allow the amendment. Court may or may not allow the amendment. This is the first part. The second part is mandatory. The second part is mandatory. And orders, no, it uses shall, and orders the court to accept application, to accept all application to accept all application necessary for the purpose of determining a real issue, determining the real issue between the parties. real issue between the parties. If it finds if it finds that the party could not have raised this matter, could not have raised this matter, party could not have raised this matter earlier in spite of due diligence. In spite of due diligence. In spite of due diligence before commencement of trial. In spite of due diligence before commencement of trial. Before commencement of trial. In spite of due diligence before commencement of trial. So, discretionary and mandatory part is clear? Even in Salem Bar, Salem Advocate Bar Association, Tamil Nadu versus Union of India, that is Salem 2, Supreme Court said that object of adding the proviso is to prevent frivolous applications which are filed to delay the trial. To delay the trial. So that should not be allowed to be done. That is not my purpose. That is not my purpose. Court may at any stage of the proceeding allow either party to alter or amend his pleading. So, you understand the two parts? Now we'll go in detail also. Who will do this? The court will do this. When it will do, it says at any stage, allow either party, so either the plaintiff or the defendant can amend his pleadings, that is plaintiff or WS both can be amended in such manner and on such terms as may be just. And all such amendments shall be made as may be necessary for determination of a real question in controversy between the parties. So basic condition for allowing amendment is determination of a real question in controversy. See, the task of court is not to punish the person concerned, parties concerned. Rather, the task of the court is to facilitate the process of justice. So I will say the object of Order 6, Rule 17, you may have a men's question, good men's question, is that the case should be tried, that the case should be tried, case should be tried on a real issue or on merits. And therefore, all amendments, therefore all amendments which are necessary for determining which are necessary for determining the real question in controversy for determining the real question in controversy, between parties should therefore be allowed. Should therefore be allowed, provided it can be done without causing injustice to the other side. Provided it can be done without causing injustice to the other side. Provided it can be done without causing injustice to the other side. Without causing injustice to the other side. Is this clear? So this is very, very important. Causing injustice to the other side. Without causing injustice to the other side, and the relief claimed should be within the period of limitation. Provided the relief claimed is within the period of limitation. If it is barred by limitation and the right has accrued to the other party, and then you question this or then you bring this matter, then this is not fair. By lapse of time, he gets a right. I'll explain it little further. Not here, on point related to it, and I come to that point within this discussion. So if your relief has been barred by limitation and now you are allowed to amend your pleading to claim that relief or bring that matter before the court, so will it not be against law? And will it not be injustice to the other party that by lapse of time he has got a right and now you are questioning that? This should not be done. It should be done at the right point of time. In this regard, there are many judgments and many points where the courts have stressed this point time and again. Time and again this has been done. And time and again it has been said by the court that only amendment should be allowed to bring the real question before the court. No? And not. So, if you are asked a question, what is the test for allowing amendment? So, the test is twin test. Test to allow amendment. Cardinal test. Cardinal test to allow amendment. The test is twofold. One, as I said, that for determination of real question in controversy, and another I said that it should be done without causing injustice to the other party. Just keep in mind these twin things. So, the cardinal or twin test for allowing amendment. We'll read further that when amendment should not be allowed. I have written in your material also. Number one, whether the amendment is necessary for determination of a real question in controversy. And number two, can amendment be allowed? Can amendment be allowed without injustice to the other side? Whether the amendment is necessary for determination of real question in controversy, can amendment be allowed without injustice to other side? If the first condition is satisfied, you write down further, if the first condition is satisfied, that the amendment is necessary to, then the amendment is necessary to decide the real controversy between the parties, then it should be allowed. Then it should be allowed. भाई आपने pleading लाया और real question ही नहीं determine हो पाए, if you have come before the court and court cannot determine the real question in controversy, what is the use of that case? That's all useless. It's infructuous. It's unnecessary. Like we are studying and we do not understand anything. What is the use of the class? So I advise all my students that whenever you read any book and you do not receive anything, don't read it. Stop. Listen to the music. Take break. Reading is not just a mechanical process. It's a mental process. Your involvement is necessary. I take frequent breaks in my class. The reason is but obvious. I want to feel energetic when I speak. I want to concentrate when I talk to you. So if it is not happening, then it is necessary to take the break. It is necessary. And obviously in such situation when you are not here, I am all alone. It is necessary. So, determination of real issue is a necessary precondition for allowing amendment. No amendment which will be allowed which cause injustice. Injustice to the other party, yes. Like I said, if some relief is barred by limitation or other party has got some right has accrued to him by lapse of time, and now you bring it by way of amendment or pleading and you claim that thing which is barred by limitation now, will it be allowed? Should it be allowed? The answer is clear, no. By lapse of time, the other party has got this right. Now that right, that settled position cannot be disturbed now. So that has to be, that has to be clear in our mind that determination of real question in controversy is one criteria, and it should not cause injustice to the other party. That is what is to be seen, whether it is in the interest of justice or not. So this is the twin test for allowing amendment. There are various tests for not allowing amendment. We'll talk about that also. Now, what other principles and factors to be kept in mind? See how I'm making points, principles or factors to be kept in mind in this regard. Kept in mind in this regard. So, first is whether it is necessary to prevent multiplicity of suit. This is one of the purpose. This is the purpose of CPC, whether it is necessary to prevent the multiplicity of suit. Yes, this serves an important purpose. So if it is yes, you should allow amendment. Why not? Why not? This is one of the main purpose of law, interest republicae, now ut sit finis litium. Interest of republic lies in the fact that there should be an end to the litigation. Let us minimize the litigation. whether the party has exercised the due diligence before seeking this amendment or pleading or not. Now, we should see. Now, see, anything should not be allowed to be used in the sense that parties start misusing it, or they make it a ground for delay, or they make it a ground for making the process lethargic and protracted. That should not be allowed to happen. So we'll see the sincerity on the part of the party. We'll see the diligence on the part of party. You may be late, but you are diligent enough. We'll appreciate. But you are not diligent and you are late and you are bringing it now, will not accept it. So you show diligence to the court, and that is what proviso says. Despite a due diligence, it could not have been brought before the court. So we'll allow. Court shall allow. So that is what I said. Court says whether the party has exercised due diligence or not. You can see this proviso also, which is written in Order 6, Rule 17. It says, no application shall be allowed after trial has commenced. So, before trial, the court is more liberal, the main provision. So, you can write down the court may allow, I change it a little bit, the court may allow amendment at any stage, even at appellate stage, revisional stage. I have no issue at any stage. At any stage. We can do it. We can correct error also at any stage. You have just seen 153A or even 153 at any stage. Court may allow amendment at any stage, even at appellate or revisional stage. No? Court may allow at any stage, allow either party to alter or amend his pleading in such manner and on such terms as may be just, and all amendments shall be made as may be necessary. That is what we have discussed earlier also, so we are not going to repeat that point. Repetition has to be avoided. The court may allow amendment at any stage. All right. Court will be restrictive in allowing amendment after trial has begun. After trial has begun. I'll bring some cases on this point. After trial has begun. Evidence stages has come and there is examination, cross-examination, and then you bring the new issue. So again it will be done. So this will be quite lethargic. So we are saying that you do it beforehand. After trial has begun, now will be restrictive. But we are not saying that we will not allow it. We are not saying that. See, law is not mathematics, I have said several times. Happy are those nations where law is not treated as mathematics. Sir, आपने ये कहा था कि ये नहीं होगा, आप कह रहे हो कि हो जाएगा. No, in this case, justice demands rules of procedure are handmade to justice. So any rules of procedure does not set any hard and fast limitation as such on the power of court. See, we said even in now this written statement case that it puts embargo on the parties, but does not deprive the power of the court to allow a party to file WS even after lapse of 90 days. You might have read it very clearly. I brought to your kind attention that significant paragraph in Salem Bar Advocate Association case, if you remember correctly. So you must be very clear that law is not mathematics. We are putting some embargo or limitation on your claim, but court is not powerless. Court can go beyond that. So I said court will be restrictive in allowing amendment after trial has begun. But we are not saying that it will not be done. We are not saying no application for amendment shall be allowed. See, the language is prescriptive. No amendment shall be allowed after trial has commenced, unless but there is relaxation. The court comes to the conclusion that in spite of due diligence, this party could not have brought it before in spite of due diligence. Then will you allow the party to suffer injustice? Will you allow this case to suffer issue due to this reason that the real controversy is not clear? Should it be allowed to happen? The answer is no. It says, shall be made as may be necessary. Now, it comes to the conclusion that in spite of due diligence, the party could not have raised the matter, could not have raised. It is not that he did not raise, it is saying that could not have raised. It means he was incapable. It is not the fact that he did not raise, he was capable, he was knowing and he did not. So that is negligence. Negligence will have no prize. Negligence has no reward. But mistake, inadvertence, omission may be excused. That is what is the law on the point. After trial, court will be restrictive in allowing amendment after trial has begun. But even after trial has begun, even after trial has begun, it can be done. Even after trial has begun, it can be done if it is shown that in spite of due diligence, that in spite of due diligence, party could not have raised it. The party could not have raised it. The party could not have raised it before commencement of trial. Before commencement of trial. Is this clear? Before commencement of trial. Is this all right? I think that I am clear to you. I think that I am clear to you. Question is at what time amendment can be allowed? At any time before commencement of trial, but afterwards it can be allowed if due diligence of party is shown that it could not have been amended earlier. Now, on this point, which I have said, there is a case Abdul Rahman versus Muhammad. Abdul Rahman versus Muhammad Ruldu. This is quoted in your Bear Act also. Abdul Rahman versus Muhammad. Case name is not important. Again, I am saying case name is not important. This is judgment today, 2012, volume 10, Supreme Court 97. It was held that if application for amendment of plant is filed after commencement of trial, it has to be shown that in spite of due diligence, it could not have been thought earlier. The court should try the merits of case that came before them and should consequently allow all amendments that may be necessary for determining the real question in controversy between the parties, provided it does not cause injustice or prejudice to the other party. So what is the sum and substance of this decision? That even if I'm writing in my own language, amendment is prayed after trial has commenced, even if amendment is prayed after trial has commenced, even then it can be, or it should be rather, you write it should be allowed. It should be allowed. It should be allowed if it is shown if it is shown that in spite of due diligence, it could not have been brought earlier. 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 The court should try the merits of the case that came before. Court should try the merit of the case that came before it and should allow amendment which is necessary. This is post amendment judgments. So even after amendment in 2002, when proviso was added in this Order 6 Rule 17, which has put some kind of restriction on court's power to allow amendment, even then the court's view are there that for allowing the true merits or for addressing the true merits of the case or real controversy in question, amendment should be allowed. But that depends on due diligence. To allow amendment which is necessary for determining a real question, in controversy, provided provided it does not cause injustice to the other party. Provided it does not cause injustice to other party. Provided it does not cause injustice to other party. Provided it does not cause injustice to other party. Is this clear? Provided it does not cause injustice to other party. Is this all right? Is this clear, my dear friend? Any point? I hope this point is clear. Let us move further. Abdul Rahman versus Muhammad Ruldu. This is then there is 2006 judgment also, Baldev Singh versus Manohar Singh, 2006 6 SCC 498. Baldev Singh versus Manohar Singh. So write down Baldev Singh versus Manohar Singh. Baldev Singh versus Manohar Singh. Baldev Singh and others versus Manohar Singh and another. Baldev Singh and others versus Manohar Singh and another. 2006 6 SCC 498. Now here I write down this point also. It says it was observed that the courts are inclined to be more liberal in allowing amendment of WS than of plant. According to the Court Order 6 Rule 17, including the proviso is a procedural provision relating to amendment of plant or WS and the limitation in respect thereof, and therefore the same should be interpreted to advance and not to retard or defeat the justice. The court will be more liberal in allowing amendment of WS, because plaint is the basis of action, and plaintiff is there and plaintiff has to give his evidence beforehand. So write down. Courts are inclined, I'll give you more details on these points. I'll read some cases, but just write down the law right now. Courts are inclined to be more liberal in allowing amendment of WS. This can be a preliminary question also. WS means written statement which you file in order 8. Amendment of WS then of plaint. According to the court, Order 6 Rule 17, including the proviso Order 6 Rule 17, including the proviso, is a procedural provision. Order 6 Rule 17, including proviso, is a procedural provision related to amendment, and it should be interpreted, it is a procedural provision and it should be interpreted to advance the justice and not to retard or defeat the justice. According to Code Order 6, Rule 17, it is procedural provision and meant to advance justice and not to defeat or retard the justice. Procedural rules or procedural provisions are handmade to justice. So you should interpret them in such a way as to advance the course of justice, not to defeat the justice. Is this clear? Now we have been using the term again and again, this due diligence. I have used it several times, due diligence. What is this due diligence? What is this due diligence? How can we say that there is due diligence and there is no due diligence? Because we are concentrating on this point time and again. We'll be bringing more example. So I just a brief comment on due diligence. What is due diligence? So you can write down due. What is due basically? If you are asked a question, what is due? Due is what is reasonable, what is expected. It is due that a junior will respect a senior. It is due that a senior will love the junior. It is due that the son will respect the father. And it is due that the son will respect the mother, and vice versa. So that is what is due, expected, reasonable. What is due of a student? That he will study sincerely, carefully, concentrate in class, solve questions. Now, what is due diligence? So you can write on that point. It is reasonable, desirable, or expected conduct. Reasonable, desirable, or expected conduct. Reasonable, desirable, or expected conduct. Diligence in this sense means sincerity. Diligence means sincerity. Sincerity. And due diligence means reasonable diligence. Reasonable diligence. Due diligence means reasonable diligence, which a prudent person is expected, which a prudent person is expected, prudent person is expected to exercise, which a prudent person is expected to exercise in his own conduct, in his own matter, affair, in his own affair, in his own conduct, in his own affair, in his own conduct. Then we have been using in proviso another expression, that once the trial has begun, then you are required to show that in spite of due diligence, this matter could not have been brought before the court. So you are required to show your prudence, you are required to show your reasonable behavior. That is what is expected. If there is undue delay, you will have to explain why it is so. Why did you not do it before? Why you erred in this matter? Where the wrong happened? So you will explain all these things to the court. So that is what is due. Now the second question is when trial commences. So you can write the brief point also on this point. Trial commences when evidence is brought. When evidence is brought. So in the intervening period, so in the intervening period, of framing of issues or settlement of issues, trial does not commence. Trial does not commence. And during that period, proviso does not apply. And then the next question is, what is the maximum time of allowing amendment? What can be the extreme limit for allowing amendment? I said it can be done at any stage. It can be done even at revisional stage or appellate stage. Because we are interested in doing justice, not in penalizing the parties. Our purpose is to facilitate justice. So if there is no real issue and we do not know the real controversy in the case, what is the use of deciding the case? It's useless. So what is the maximum time for allowing amendment? So you write down, however negligent or careless, however negligent or careless, however negligent or careless may have been the first omission, however negligent or careless may have been the first omission, and howsoever late the proposed amendment, and howsoever late the proposed amendment may be, however the late, however late the proposed amendment may be, comma, it should be allowed. It should be allowed if it can be done without injustice to the other party. If it can be done without injustice to the other party. If it can be done without injustice to the other party. And there is no injustice, and there is no injustice, and there is no injustice, if the other party can be compensated, and there is no injustice, if the other party can be compensated, there is no injustice if the other party can be compensated by the cost. There is no injustice if the other party can be compensated by the cost. If the other party can be compensated by the cost, and cost is panacea to all ills. So this is a kind of treatment to all problems, cost. Cost is panacea to all ills. So if the other party can be compensated by cost, then we have no problem. Commencement of trial has been clarified by many courts in many cases. Now there is a case Vidya Bhai versus Padmalatha, AIR 2009, Supreme Court 1433. This case says that the date on which issues are framed is the date of first hearing. You know this, and I'll tell you further also. Provision of CPC envisages taking of various steps at different stages of proceeding. Filing of affidavit in lieu of examination in chief of the witness would amount to commencement of trial, because you are giving evidence now. Filing of affidavit, you can give evidence by affidavit, you know this. I think order 19 or 18, you talk about evidence, no? Filing of affidavit in lieu of examination in chief of witness would amount to commencement of trial. Examination in chief, you know, when you call the witness of yours and you examine him in the court. That is examination in chief. Then there will be cross-examination when your witness will be examined by other party. So, filing of affidavit in lieu of examination in chief, examination in chief of witness would amount to commencement of trial, because you are producing evidence. I have already told you that. Baldev Singh, Manohar Singh, मैंने कह ही दिया. See, there is a case, Brij Gopal Pelod and others versus Municipal Council, Jahirabad. Now, in this case, the trial of suit said to have commenced when the trial court makes the chief examination of the first witness in the suit presented in form of an affidavit as part of record after verification of its content on examination of document mentioned therein from the point of view of admissibility, and when such a witness is available for cross-examination by the opposite party. So, when the trial commences, you listen to me carefully, it says, trial of suit said to have commenced when the trial court makes chief examination of the first witness. So, examination begins, trial begins. Chief examination of the first witness in the suit presented in the form of an affidavit. So, if he presents the affidavit, that is equivalent as part of record. And it is done after verification of content and on examination of document mentioned therein from the point of view of admissibility. So, even if document is produced, there is no beginning of trial, because we are examining whether this document is admissible or not. If document is not admissible, then evidence law will come in picture and you cannot admit that in evidence. So, admissibility of document, production of document and admissibility of document for the purpose of using it as an evidence is not trial. The trial will commence when there will be first chief examination of the witness, or there will be first production of affidavit in lieu of examination in chief. Then the trial begins. So, you can write down Brij Gopal. Case is not important. You rather leave this case. The citation is also not relevant, because this. You write down the trial commences when there is examination in chief of first witness. The moment you do it, start it, examination. Now this begins. This begins. This begins. This begins. And not when document is produced for verification of content and admissibility. This is just for your understanding. So I hope trial commences you understand this point. Then let us see another thing. What types of amendment is allowed and what types of amendment can be refused? Sorry. We have framed many questions. What types of amendment will be allowed? So frame a question, answer it. What types of amendment will be allowed? What types of amendment? So I tell you, it all depends on facts and circumstances. There is no straitjacket formula as such. The courts have wide discretion, but courts' power must be exercised judiciously and with great care and caution. So you can write down the answer. It depends on facts and circumstances. Like I said, it can be done on in appellate stage, even in revisional stage. It can be done at any stage. It depends on facts or circumstances of each case. There is no straitjacket formula. There is no straitjacket formula, and the courts have wide discretion. The courts have wide discretion in matter of amendment of pleading, but discretion must be exercised with great care and caution. With great care and caution. With great care and caution. Courts have wide discretion, but discretion must be exercised with great care and caution. Is this clear? Furthermore, it must be exercised with great care and caution. All right. This is correct. I hope you understand this. This is very simple general point which I am making. Court's power must be exercised with great care and caution. There is no doubt about this. In general, you can write down further. In general, when it will be done? In general, the following amendments or following types of amendment will be allowed. Following types of amendment will be allowed. The following types of amendment will be allowed. Like number one, grant of consequential relief. Like from job you have been suspended. Now you challenge the suspension and you claim the arrears of salary also, but you forgot to claim the arrears of salary. No. So in that case, that is consequential. So you can add this. You can add this to avoid multiplicity of proceedings. Court will also encourage this, that if for this another suit will be brought, so why not allow amendment here and why not to decide this matter here? To avoid multiplicity of proceeding. To avoid multiplicity of proceeding. To avoid multiplicity of taking notice of subsequent event. Now there is subsequent things which has happened or which have come to your knowledge. So now you are convinced that this should be also brought before the court, where the amendment is formal in nature, then there is no issue. It is related to form to clarify the pleadings. If there is anything which is not clear and clarification is necessary, you can add it. So you can write down to clarify the pleading. This is simple, I think. Where amendment is formal in nature. It is not anything substantial, formal in nature. Like we forgot to mention the particular rule, particular provision, or we mentioned to now write it in proper manner, formal. Where the parties in plant are wrongly described, I have already told you that there can be addition or striking of the parties also. So I said where the parties in plant are wrongly described. Parties in plant are wrongly described. Where the parties in plant are wrongly described. Where some properties are omitted from the plant by inadvertence. So this is also some kind of clerical things. Where there is mistake in a statement of cause of action. So omission of properties or object by mistake in plant. Next, where there is mistake in a statement of cause of action. Where there is mistake in cause of action. Where there is mistake in cause of action. Bona fide omission in making necessary averments. Bona fide mistake. Averments, that is statement. Bona fide mistakes in averments. Averments, that is statement. Averments. Averments, that is statements. Bona fide mistakes in averments. When this amendment will be refused, when amendments will be refused. So answer is where it is not necessary to determine the real question. Perfectly so. When it is not necessary to determine a real question in controversy. Introducing totally different, new and inconsistent case. They are general observations introducing totally different, new and inconsistent case. Or which changes the fundamental nature of suit. I'll explain all this, don't worry. This requires little bit clarification. I will give examples and I'll clarify these all points. Where the effect of proposed amendment is to take away from the other side a legal right accrued in his favor. I have given examples in your material also. You can look into your material, please. Where the effect of proposed amendment, where the effect of proposed amendment is to take away where the effect of proposed amendment is to take away from the other side take away from the other side a legal right accrued in his favor. Legal right accrued in his favor. Legal right accrued in his favor when it is not bona fide. Now we'll explain this one by one. When it is not bona fide, just hold for a few minutes. I'll explain all of them. We'll do it. Just have few minutes break. When you get tired, learn to rest, not to quit. Is this clear? When you get tired, learn to rest, not to quit. चलो आप कहते हो तो मान लेते हैं, कोई नहीं, हमें कोई समस्या नहीं है, हम तो मान ही लेंगे। आपकी बात को मैं उठा नहीं सकता। नहीं, मैं तो आपकी बात दोस्तों मानूंगा ही मानूंगा। No, 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 no. Very good, very good, my dear friends. Very, very good. So, those four things which I have brought to your kind attention. Amendment of pleading. When the amendment is uh, for not necessary for purpose of determining the real question in controversy. Now you read this material, page 71, 72, 73 and 74, and try to solve the question also, no? Question solving, I think you have started, no? You have started everything, so please start doing the questions and let us do it now. Now onwards, we must solve questions. So, amendment of pleading may be refused in which cases? So, I said when amendment is not necessary for purpose of determining the real question in controversy. अब देखिए इसको आप पढ़िएगा, page 71, I am not reading it, but you just read it, I can explain little bit. Above principle is well illustrated in the case of Adhiniyam versus Cohen. This is English case from where we have borrowed this. B and C wrongfully removed A's furniture. A sued B for damages and got a judgment against B. A afterwards sues C for damages for the same wrong. C does not plead judgment against B in his defense. Because B and C both being joint tortfeasors, the suit against B prevents A from suing C. Instead, after evidence for A was over, applied for leave to amend his WS by pleading that the judgment against B stood as a bar to the suit against. The application for amendment was rejected, as amendment in question was not necessary to determine the real question between the parties, but intended merely to enable C to avail himself of a technical rule of law. The court did not allow that. You should have brought this matter beforehand. Nothing great, it's very simple. So, on first point, where it is not necessary for determination of real question in controversy, there is a case, Adhiniyam versus Cohen. This is the case, Adhiniyam versus Cohen. Old English case. (1889). So you can see this is how old it is. B and C removed furniture of A. Okay? So without permission, that is, they have done wrong. So A can file case against both B and C. But what he did? A filed a case against B and got judgment against B. A filed a case against B, got judgment against B. Afterwards, A files case against C. The moment he files case against C, B and C are joint tortfeasors. They are joint tortfeasors. So he can easily plead this defense that, see, there is a judgment against B now, which bars you to file case against me, because it is same cause of action. So your suit is barred. But he did not do it. He did not do it. He did not do it. When plaintiff's evidence is over, so A has given all his evidence, it is over. So trial has begun. Trial has begun. Evidence of A is over. Plaintiff has given his evidence first. Now he comes with an argument that, now see, there is judgment against this B, which bars any case against me, that is C. Now the question is, will this prayer be allowed to be amended? Whether the pleading will be allowed to be amended by defendant, that is WS, can be allowed to be amended by this C now. The court says no. It is not necessary for determination of real question in controversy. So why unnecessary allow this? This is only a technical rule of defense. It is not necessary for determination of real question. Real question is whether now B and C are liable or not, whether they have done wrong or not. Now this amendment only gives benefit to C, that C will not be further prosecuted in this case. But why it should be allowed? It is only a technical rule of defense. It is not necessary for determination of real question in controversy. The court says that it has nothing to do with the determination of real question in controversy, so let case go. He has given already his defense, now already his evidence. He will give his evidence, the case is over. Why unnecessary allow this? This is the point. Rest I will request you to read yourself this, and then I will discuss it tomorrow, don't worry for that. And I will discuss various cases. I have told you to watch that video lecture which you must have watched. I hope so. You must have watched that lecture. Sonia Mehra versus Manisha Rawat, Delhi High Court judgment. Sonia Mehra versus Manisha Rawat. This is one case. J. Ram Manohar Lal versus National Building Material. Another case. Sarabjit Kaur versus Joginder Singh. Another case. So Sonia Mehra versus Manisha Rawat. You just read this. भाई ये केस डालना भी ऐप में जरा, मैं ये केस डलवा भी देता हूँ ऐप में, देखता हूँ अभी. सोनिया मेहरा वर्सेस मनीषा रावत. There are many cases. Tibarani, this is judgment of Delhi High Court. But very important case. Sonia Mehra. And Saribjit Kaur is also very important case. Now this can be a good question. This can be good question. Punjab and Haryana High Court judgment. Sarabjit Kaur versus Joginder Singh. This is another case. M. Ravanna, Mount Mary, Mahila Ramkali Devi. भाई ये केस को डालो ऐप में जरा। सोनिया मेहरा वर्सेस मनीषा रावत। पर क्लियर डालना, ये पेज पे भी डॉट्स आए हुए हैं। 4 पेज है ये, एक एक करके डालना है, सब डालना है ये। सोनिया मेहरा डालो और ये सरबजीत कौर डालो, सरबजीत कौर। ये उतना इम्पोर्टेंट है, इसको पढ़ाएंगे कल क्लास में। पेज सोनिया मेहरा, सरबजीत कौर एंड एम रेवन्ना। माउंट मैरी, एम रमन्ना। नीरज, तो मैं आपको बताऊंगा, अमेंडमेंट ऑफ डब्ल्यूएस पे भी चर्चा करूंगा। आई हैव गॉट ए केस, उषा बाला साहेब स्वामी वर्सेस किरण अपासो स्वामी। उषा बाला साहब स्वामी वर्सेस किरण अपासो स्वामी। दिस इज ऑन अमेंडमेंट ऑफ डब्ल्यूएस। ये भी डालो, माउंट मैरी। माउंट मैरी। I will discuss all these cases tomorrow, don't worry. Then will be clear. Sonia Mehra, etc. is very important on the point. If you do not understand the case, then you will not be able to understand the theory. So theory part I have discussed. Now I will bring before you the examples in form of these cases, and then you will learn it better. Because in your examination, it is very much required that you must understand the application. And if you apply little bit yourself, you will understand the application very easily. It's very interesting, fascinating to understand the application. Application is rather enjoyable, theory is not. So please change your way of thinking, that if you think that cases are difficult, it is not so. Just you are required to practice it. You start reading, you will learn it better. You will learn it better, I tell you. You start reading cases, it's quite enjoyable, useful. And this is how we learn law. This is how we become a good lawyer, become a good judge. Suppose tomorrow you go to court as a judge or a lawyer, you have to apply the law there. So application of law must be understood. Is it clear? So I am sending all these cases in your app. Please read them if you can. Otherwise, I will help you. And I have given lecture on Order 6, Rule 17. I have shared with you that lecture. The institute has shared with you that lecture, and I hope that will help you to understand better. Is this clear? Is this clear, my dear friend? Is this clear? आपको बात मेरी समझ में आ गई? Please read those cases. I'll be back tomorrow and I'll deal with these cases, and I will deal with this amendment of pleading further, and we'll finish this. Is this clear? Okay, bye bye. कल मिलते हैं और बातें करते हैं.